Hey outside world, very quick video this morning. Just wanted to follow up on a promise I made on Twitter, TM Thomas, about the lawsuit that was filed on National Girls and Women's Sport Day, ironic, between the U.S. Soccer Federation and the U.S. Women's National Team Player Association. Player Association is a union, just like the NFLPA, the WNBAPA, anyone out there. Why I had to pause before I could think of another pro league, I don't know. I watch sports all the time. That said, the dispute, the union, which is a group of players who come together to negotiate as a whole because the benefits they get as a unit are better than going individually. There's some give and take. Some stars may make less money than they would going solo, but the rest of the team might make more. Things like travel perks and per diems and whatnot work better when they're negotiated for a group. It's a little different than some of the others because we don't think of U.S. Soccer as a sports league or an employer, but reality, it employs these women and the men who it pays much more for much less success on better fields. And you begin to see where some of this problem's going. So when a union and an employer negotiate an agreement, it's usually known as a collective bargaining agreement or a CBA. These are all special terms that are from a law called the National Labor Relations Act, which governs how unions and employers interact. The dispute currently is whether the CBA is in effect as extended by some negotiated additions, some memorandums of understanding or MOUs, or rather the CBA expired and these negotiated extensions don't have a lot of legal effect. So it's a lawyer fight. There's a lot of slapping and hair pulling and what lawyers do when they get together. That seems to be a lot of negotiation related stuff going into whether or not the women are going to see a pay raise or changes in their terms and conditions or the NWSL requirements, how things are going to shake out there. In a lot of ways, it's almost nothing because it's a negotiated posturing. It's all part of what's going on at the bargaining table. It may not really amount to anything. What was of more interest to me and has caught the attention of a lot of other people is the exhibits. U.S. Soccer in their exhibits included a declaration form which gets fired to the Department of Labor from the union, which listed the addresses and phone numbers for some of the union officers and listed what appear to be home addresses for the union members at that time, which that's not protected material that's required to be redacted, but when these are valuable employees who are important to the league, or well, both the league and the federation, doesn't seem like a great move. It seems like it puts people potentially in danger, open to harassment, open to annoyances and nuisances. It also included some emails that had unredacted email addresses for some current players. On its face, seems less scary than people showing up at your door, but for identity theft purposes, these are very public people with a lot of information, mother's maiden name, first car, all those standard questions. So they're much more open to identity theft if there are private email addresses out there. Was this a mistake or an act of war? I can't say to that. I'm not sure what the bargaining positions are of either side, but that's the angle on this story that has me the most interested right now because it seems like a major snafu or major stupidity or major aggression. And I'm not sure which it is. I'm waiting to find out. But that's what it is. It's a dispute over whether the collective bargaining agreement is in effect or not for negotiating purposes as the players and the league work out a new deal. So there's 5 minutes on what's going on. Any questions or comments, put them down below. Please like this. Please subscribe for more law and women's soccer, and we'll talk to you soon.